All right, welcome everybody. Come on in, sit down, wander in. Don't leave any empty chairs. If you can hear the sound of my voice, raise your hand in the GoToWebinar hand raising control panel. There we go. That always makes me feel better. Well, today's is an important topic. I'm starting to get more questions about this from people that I'm mentoring, agents, things like that, as well as others. Let's see what this is. And so a lot of the landlord tenant and COVID issues are really legal issues. And so I've invited an attorney to speak to us about those issues. So I want to introduce Anna Lou, who's a partner with Stephen Adair McDonald and Partners, which is based in San Francisco, but I assume you work the Bay Area and, you know, you can do remote
Yep.
attorneying. Anna Lou is a partner in Stephen Adair McDonald and Partners in San Francisco, focused on real estate litigation, represents clients in a variety of real property matters, including commercial, residential, landlord-tenant actions, co-ownership, and buyer-seller disputes. And there's more to her bio, but I'm going to save that for you guys. So why don't you take it away, Anna? And if you guys have questions, type them in. We'll either get to them as we're going along if they're really good questions. Otherwise, we'll cover them at the end. Do you want to take it away now?
Yes, Michael, thank you very much for inviting me. I'm happy to join you and talk about the ever-changing laws around the landlord-tenant real estate realm, particularly when selling or buying a property that is tenant-occupied. So thank you for having me today. I am sharing my screen. This PowerPoint will also be available. It's included in the handout. So as Michael said, my name is Anna Liu. I'm a partner with Stephen Adair McDonald and Partners. We're located in San Francisco. We do help clients all throughout the San Francisco Bay Area. All right, let's dive right in. So what are we going to cover today? I've put together 4 broad topics. I have about half an hour worth of material to cover. Just to preface that, these laws, I could easily spend hours talking about them because there's so much depth and they're very dense, but for purposes of our presentation today, I've condensed what could be hours of material down into 30 minutes into bite-sized, manageable chunks. So we're going to talk about questions that I get very often from realtors, including what are my rights to access a tenant-occupied unit, especially during COVID-19. I'm also going to share some updates on the current eviction moratoria, what's going on at both the local, state, and federal levels. And then I'll spend a little bit of time on potential options for maximizing property values if they're tenant occupied, perhaps buyouts. And I threw in rent freezes in there because the topic's interesting to me, and I surveyed a few cities that currently have rent freezes in effect. Good to know if you're representing sellers who may have questions about that. I'll preface that also by saying, don't give any legal advice. You should always direct sellers if they have questions about legal implications to talk to an attorney. All right, tenant occupied properties. So these types of properties can present additional opportunities for buyer and seller clients. So your clients don't have to shy away if a property is tenant occupied. You know, especially for buyers under the right set of circumstances, you know, you can expand your potential list of properties and not pass up on looking at tenant occupied properties. And, you know, buyers may want to move in and owner occupy. Also, if you're a seller, we'll talk about ways to maximize the value of the property, including potentially trying to have the tenant leave before marketing and listing tenant occupied property. There are a lot of restrictions on that right now because of COVID-19. The question that I get the most thus far and over the past year has been, what are my rights to access a tenant's unit to show it to prospective buyers, especially given the pandemic? So the statute that governs this is California Civil Code Section 1954. It does allow a real estate agent to enter a tenant's unit to show it to prospective buyers. But the property owner or the agent will need to serve a lawful 24-hour notice in advance of the entry, and the entry must be made during normal business hours. It's really important that your 24-hour notice is given a minimum of 24 hours in advance of the entry, but also it has to be served properly. So a text message to a tenant, an email to a tenant, that is not proper service. It's got to be posted on the tenant's door, mail a copy. If you do mail a copy only, you've got to account for that time for mailing. So the best way to serve that is by either hand delivering it to the tenant or posting a copy of their the notice on their door and then mailing thereafter. Text message, email, not valid forms of service. Also, what goes into your 24-hour notice is important. You can't just say, hey there, we're coming in on Monday at 5 p.m. It's got to have very specific language in there. Otherwise, a lot of attorneys who represent tenants may push back and say, you didn't give us valid notice, we're not letting you in. So all of that has changed a little bit because of COVID-19, and the rules vary city to city, county to county, but generally in many counties, the tenant needs to consent to the entry during COVID, and they should not be present during the showing. And in many cities and counties, the showings are limited to 2 persons plus their agent. Usually the 2 people should be buyers of the same household, but again, those rules really vary depending on where the property is located. So check your rules, make sure you're staying up to date. Next, I wanted to get into Senate Bill 91, which is the statewide Tenant Protection Act. And it's important for realtors to be aware of this because if their seller clients are selling the property and they don't want to sell it with the tenant in there, there are restrictions right now on what a seller can do. So what is Senate Bill 91? Why don't we just start there? It is a state law. It was signed by Governor Gavin Newsom back on January 29th of 2021. It went into effect immediately, and it extended an eviction moratorium through June 30th of 2021. So a couple months more of this law, unless it gets extended further. Chatter in the industry is that the chances of this getting extended are pretty high, but we'll see. It creates substantial tenant protections for non-payment of rent plus additional procedural requirements. So tenants who haven't paid rent, this law applies to them, but it also protects tenants from evictions while the pandemic is going on, and it extended local eviction protections through June 30th as well, which I'll touch on. And it's a housing law that property owners really do need to be aware of, as well as agents who are working with tenant-occupied properties. And the reason I have extension of AB 3088 on this slide is because AB 3088 was a former version of this law that expired, and Senate Bill 91 just extended that law. So the key components, as I mentioned, there are new protections if tenants aren't paying rent. There's new procedural requirements. There's new just cause for eviction protections to all residential tenants through June 30th, with just a few minor exceptions. This law puts limits on local eviction moratoria, and then this law also put a burden on property owners to give a new pre-notice if tenants haven't paid rent, which I won't spend too much time on for purposes of this presentation, but wanted to put it on your radar to be aware of. Also, other new resident protections are added with this new law. The protections are in effect again through June 30th, and nothing in this law makes the tenant's rent go away. All the rent is still owed. It can just be potentially deferred if the tenants qualify. And it also delays property owners' abilities to file lawsuits to collect unpaid rent, particularly in small claims court or through a general civil lawsuit. And this new law applies to residential tenants, not commercial. So I think that's really important. I get a lot of questions about, what about a commercial tenant? This particular law, we're talking about CTRA. We call it CITRA. CTRA stands for the COVID Tenant Relief Act. This does not apply to commercial tenancies, but there are many laws that have now given commercial tenants additional protections, and those also vary greatly from city and county. So the law that we're talking about right now, Citra, it only applies to residential units, not commercial. It also does not apply to corporate rentals if the renter is not a non-natural person, and it doesn't apply to transient occupancy like guests of hotels and motels. I'm not going to spend a lot of time on these particular slides because these are more notice requirements and they have to deal with non-payment of rent, but I wanted you to at least have the materials so you know that there are these different rental periods when tenants haven't paid rent and what property owners can or can't do. And so the reason why this is important for agents to be aware of is because if you're selling a property that's tenant occupied and your client comes to you and says, my tenant hasn't paid rent, what do you know about that situation? Well, here you go. Here's a slide that really talks about what happens right now with non-payment of rent situations. Also, you'll need to disclose that in the disclosure packet. So it's just good to be aware that these new laws are on the books right now. So here's the slide. Like I said, I won't dive into the nitty-gritty of it too much other than to say this new law applies to all tenant rent payments that became due between March 1st of last year and June 30th of this year. And the law divides the rent periods into two different types of periods. One is called the protected time period. And as you'll see on the slide, that's from March 1st of last year through August 31st of last year. And then the transition time period, that is considered rent that's due between September and June 30th of this year. And the reason it's broken up is because property owners would need to serve two different types of non-payment of rent notices depending on when the rent payments fall. So like I said, I'm not gonna spend a lot of time getting into the nitty-gritty of this, but just be aware that if you have clients whose tenants haven't paid rent, there are going to be restrictions on the property owner's ability to seek rent and then recover the property if the tenant doesn't pay. Also, new notice requirements, just wanted to point out that usually we all know, 3-day notice, pay rent or quit. Well, not anymore. Now the notice period, at least through June 30th, is going to be a 15-day notice period, and that's 15 court days. So that doesn't count weekends or judicial court holidays. So it's actually a little bit longer than 15 actual days. The slide also includes other important notice requirements that now have to go into that 15-day notice. So if you ever hear your client say, hey, can I serve a 3-day notice? That should trigger you to think, wait a minute, 15-day notice is now for non-payment. Again, shouldn't be giving legal advice, but should be aware of all of these new changes under this new law. If a tenant can claim that they have been impacted financially by COVID-19, then they will be able to provide a declaration in response to being served with a 15-day notice. And they'll have to state under penalty of perjury that they're unable to pay their rent or other financial obligations under the lease because of one of these 6 different reasons that the law has put forth. And the one that we see most often in our office is reason number 6 on this slide, which says, others, I can't pay my rent because of circumstances related to COVID that have reduced my income or increased my expenses. And the reason I'm highlighting number 6 is because that is a very, very broad statement. And, most people can probably claim they had some kind of increased expense or potentially reduced income because of COVID-19. So it's pretty low threshold for tenants to be able to claim a hardship under this new law. And then there's just an extra rule for high income tenants. And so I just wanted to put that out there. Not going to spend a lot of time on this particular slide, but to say that if tenants are high income and there's a definition of at least a household income of $100,000 or 130% of the median income, then other additional requirements would apply if tenants are high income. They'd have to show proof of why they are unable to pay their rent. But that only applies if they're high income. So just something to be aware of, again, in the context of this new law. I also wanted to share that there is a new rental assistance program under this Senate Bill 91. And what that means is if tenants haven't paid rent during specific time periods, then property owners can apply to receive rental assistance from the state. The application period opened back on March 15th. And the website to go to for all of that information is on the slide. It's housingiskey.com. That website has the applications, the requirements, eligibility, what you need to basically recover some rent and get some assistance during the pandemic. And the money, if a tenant applies or a landlord applies, it will be awarded in 3 different rounds, and the state is prioritizing certain groups over others, including income-based requirements. So if tenants make less than 50% of the area median income, they'll be prioritized first. So just something, again, to be aware of, that the state is offering rental assistance, and the assistance only covers up to 80% of any unpaid rent owed from April 1st through March 31st, which means April 1st of last year to March 31st of this year. So basically landlords can get 80 cents on the dollar, and they'll have to forgive the remaining 20 cents on the dollar if they apply and receive the money. And so if a landlord chooses not to participate, tenants still can apply, but the tenant portion will only be capped at about 25%. And if a landlord applies but a tenant refuses to cooperate, then what that means is the application will be denied outright. So it really takes both parties cooperating together for property owners to get that rental assistance. Okay, this is more what I wanted to get to, which is why I didn't spend too much time on the prior slides. But AB 1482 was a law that was enacted last year, and this is the temporary expansion of just cause for eviction requirements under CITRA. So the reason why this is important for agents to be aware of is because AB 1482, also known as the Tenant Protection Act, or TPA as you may have seen it, it imposes both rent control, which is not the focus of today, but just cause or reasons why property owners have to remove tenants from their property. And the reason why I'm talking about it in the context of this new law is because Senate Bill 91, the law we were just talking about, also extended just cause protection to tenants through June 30th, and the just cause reasons are under AB 1482. So just taking a step back, in September of 2019, the Tenant Protection Act was signed into law. It went into effect January 1st of last year, and it imposes rent control on certain residential properties. It also requires landlords to have just cause in order to terminate a tenancy. And there are 2 different broad groups of just cause. So the first is fault-based, where the tenant has done something wrong, they are at fault. Usually the reasons include tenant didn't pay rent, tenant breached something in the lease, tenant is refusing access, refusing to allow a property owner or their agent to enter the property for showings. Those are all considered fault-based reasons under the Tenant Protection Act. But again, you have to look at the lease to see if the lease has any specific language in there to see if it's a breach of the lease. So the other section are no fault-based reasons, where the tenant has not done anything wrong, but the property owner wants to recover possession. And this could be, for example, if they want to have the tenant leave and sell the property. I get a lot of questions about that and how this law applies, which I'll touch on in a minute. So again, there are all the just cause reasons, but there is an exception under CITRA, this new law we're talking about, if a property owner is going to sell a single family home or a condo. So this exception to just cause, meaning a property owner doesn't need to have just cause, as long as it fits this very, very narrow window. And so what it is the very limited exception from just cause is if the property owner is selling a single family home or a condo, and they're in the process of selling the unit, and they are selling to a buyer who states that they intend to own or occupy once escrow closes. So the reason that is a little complicated and very specific is because when a property owner serves their eviction notice to have the tenant leave, they already have to be in contract to sell the property, and the buyer has to intend to own or occupy. And those two things have to also be in play at the time the service of an eviction notice is done. So a lot of property owners choose not to go this route because they want to market the property as vacant when they're selling. And so when you are in this situation, you already have to be in contract before the tenant even leaves. So in my opinion, it's a very narrow exception that is quite difficult to meet. But I wanted you to be aware that that exception is out there right now, and that's in play through June 30th of this year. There are also a couple of other ties to what I just said. So the single family home or condo cannot be owned by a real estate investment trust, a corporation, or a limited liability corporation in which at least one member is a corporation. So in other words, the single family home or condo really needs to be owned by an individual. It can't be owned by any of those three entities. And the landlord has to give notice of this exemption to the tenant in their lease. So that's why I say it's a very hard exception to meet, because one, it's got to be single family home or condo. Two, it's got to be owned basically by an individual. And three, you have to give notice to the tenant of all of those things in their lease. And then number four, the seller has to be in contract with a buyer who intends to own or occupy the property. So I think, in my opinion, it's difficult to meet all of those things to take advantage of this exception to just cause for evictions. I threw a slide in here about some language that has to go in the lease to give that tenant notice, and it applies if the lease is starting or renewed after July 1st of last year. Then that notice must be in the lease. Couple more exceptions. What I just talked about does not apply to tenancies that were already terminated before March 1st of last year, and that eviction notice had to expire before March 1st of last year, and the landlord could not have waived that notice. For example, by taking rent after they've served the notice, that would waive an eviction notice, or by telling the tenant, we're not going to move forward with that eviction notice. That can also be conduct that is an example of a waiver. I wanted to briefly touch on the interaction of this new law with other laws at the federal and local level. The CARES Act, basically what we need to know is there's potentially a 30-day notice required if the property has a federally backed mortgage, or if the property participates in federal subsidy programs. For example, there's a Section 8 tenant there who receives Section 8 assistance with their rent. So this really comes into play if there's a federally backed mortgage on the property. If not, CARES Act would not apply. And then similarly, the CDC also enacted a eviction moratorium. You've probably seen it on the news. There have been a couple of courts in other states at the federal level that have struck down the CDC eviction moratorium. But right now, it's currently in effect through June 30th as well. And the CDC eviction moratorium basically prohibits evictions based on non-payment of rent if the tenant has suffered and can show a hardship, and there's other protections. So I won't get into too much on the CDC level, but important to note that there are various eviction moratoria protections on both the state, federal, and local levels. I gave an example on this slide of certain preemption of local eviction moratorium. There are various dates that are involved. I don't want to spend a lot of time on this because it may not really come up in your day-to-day sales, but I just wanted you to be aware that there's an interplay between everything we just talked about and then local law levels. So you've got to check at levels, local, state, and federal. I gave a quick example of the San Francisco eviction moratorium because it is currently in effect, and I wanted to just give one county example of what for example, the city of San Francisco has done. Oakland also has a temporary eviction moratorium, and so do other cities. San Francisco's basically only 3 types of evictions can go forward in San Francisco right now. They are the non-payment of rent, subject to the rules we just covered. If the owner is doing an Ellis Act eviction, which means they're removing the property from the rental market and not going to re-rent, or the bigger exception is if the eviction is necessary due to violence, threats, or health or safety issues. Those are the only 3 evictions that can carry forward right now in San Francisco, but the San Francisco sheriff is not actually carrying out evictions and physically removing tenants unless it's necessary due to violence related issues or health and safety issues. So there's a lot to kind of go over and cover. I just wanted everyone to be aware of an example of one city, San Francisco, that has even further restricted evictions than what we just talked about. The rent freezes that are currently in effect, I pulled a few just so property owners can be aware, but San Francisco had a rent freeze. It expired back in October of last year, wasn't renewed. Contra Costa County does have one. Their rent freeze is in effect through June 30th. Oakland has a rent freeze as well. It's capping rent increases to 2.7%. Basically, you can't increase above the current CPI. And then San Mateo County, there are no rent freezes in effect. There's also, I put on the slide, the California anti-price gouging statute. And what that means is when there is a declared state of emergency, you cannot raise the rent more than 10% during that declared state of emergency. So I'll get calls a lot saying, you know, hey, I'd like to raise my rent, 15% in a non-rent controlled jurisdiction. Can I do that as a way to get my tenant to move out so I can sell the property empty? And right now, no, Penal Code Section 396 is going to block any rent increase over 10%. So a lot of people say, well, if I can't get the tenant out and I don't have just cause, then what are my other options? And so buyouts are a particular option that a lot of our clients are utilizing. You may have heard of cash for keys, tenant incentives to leave. Those are all different ways of talking about buyouts. Certain cities like Oakland and San Francisco have requirements before property owners can, or real estate agents, anyone can negotiate a buyout. Certain disclosures have to be served on tenants and filed with the rent board. I threw together some statistics just to kind of see what average buyouts, at least in San Francisco, are going for, because the rent board has been tracking those amounts. So in 2020, there were about 615 landlord declarations filed with the rent board, which means that 615 landlords said, hey, I want to talk to a tenant about a buyout. And of the 615, about half, or 333 buyout agreements, were actually filed with the rent board. And then these numbers come from the rent board. Looks like in 2020, the average buyout was around $29,000 per tenant, but that's just in San Francisco. And again, those are the ones that were reported. I'm sure there are many that kind of go under the table that are unreported. Unlawfully, you have to comply. But I suspect that there could be, some that go unreported. So just to kind of close, I wanted to share that these laws are always changing. I updated this morning, so the rules are current as of at least today. Things could change later. And, you just have to kind of keep checking the rules and stay up to date. One other thing before I close with my final minute is I wanted to share, watch out for, if you are representing a buyer, watch out for seller rentbacks. That's when a seller is selling and they say, I'd like to stay in possession after escrow closes for X number of days. And, we want to, a seller rentback, we want to stay in the property. Be really careful of those. You may want to advise your clients to talk to an attorney about that. I've had maybe 4 or 5 seller rentback issues in the last few weeks where the rentback was set up as a lease. So the seller was paying rent. And then the seller, at least in the cases that came through my office, they didn't end up moving out and leaving. And in some of those cases, the sellers now have tenant rights. And then they're subject to all of the rules we just talked about. So I just wanted to, it's not in my slides, but I just wanted to highlight that I've been seeing quite a few seller rentback issues. So there are ways that the rentback can be structured, calling it a license to occupy. Those rules will vary by a different city, but just watch out for that because we're seeing more and more of those lately. So I think I am right on time at 1 o'clock. I will turn it back over to Michael.
All right, thanks, Hannah. That was great. I have let me ask you a couple of questions if I may. So let's say the seller wants to sell the property, there's a tenant in it. One of the things on the list that I saw for why a landlord can give notice to a tenant is we're planning on removing it from the rental market.
Mm-hmm.
Right. Now, from one point of view, they're removing it from the rental market because they want to sell the property without the tenant. But I've heard that it's more complicated than simply saying, I've decided I don't want it to be rented out by anybody, so you have to leave in 60 days. Is that true?
Great question. If we're talking about a non-rent or eviction control jurisdiction like San Mateo County, for example, where there is no separate eviction control, then a lot of our property owner clients are serving, who want to sell the property tenant without their tenant, they are serving 60-day notices based on removal of the property from the rental market. And it can be a little complicated because of the good faith elements. Generally, that just cause is reserved for property owners who just don't want to be landlords anymore. But the way the TPA or the Tenant Protection Act is written, it doesn't have those requirements that the landlord not re-rent the property for a certain number of years. That's different compared to Berkeley, Oakland, San Francisco, where there are restrictions on re-rental. So we are seeing property owners serve 60-day notices in non-eviction controlled jurisdictions to get around that. I just say the caveat is it's not as clean and quick as some may think. So again, best to get advice about that before serving like that.
Right. We see the obvious problem with you have to have a contract with a buyer who's going to live there in order to give a 60-day notice, because escrow doesn't take 60 days, right?
Mm-hmm.
30, which means that you can't deliver possession to the buyer by the day escrow closes, which is a sort of a mandatory rent back,
Mm-hmm.
right? That is
Mm-hmm.
continue the current lease for that for the rest of the 60 days. So one of the ways to get around that I've heard is the owner says, I don't have any intention of ever renting this property out again. I'm going to sell it. So I'm going to remove it from the rental market now because that's going to make it easier for me to sell it. I'll never rent it again. It will be gone. You can understand that logic. Is that I know they should always talk to a lawyer, but is that a possible justification for removing, for giving the 60-day notice?
It is, with potential problems if the tenant does lawyer up and try to fight that notice. And again, that only works in counties where there isn't a eviction control ordinance, because for example, if it were in Berkeley or Oakland or San Francisco, those restrictions go with the new owner. So the new owner will step into the shoes of the former owner and will not be able to re-rent. But because the TPA doesn't set number of years or months that a property owner would not be able to re-rent, it seemingly is working in areas that don't have those restrictions. So, to try and give like a real just short answer to it, there is never really a answer, but yeah, to try to keep it short, it's possible that can work, but there are potential pitfalls that just need to be explained so property owners can make informed decisions.
Right, and that would probably be better from a lawyer than a real estate agent. Is there any difference in the way these rules are applied if it's month-to-month versus a fixed-term lease?
Yep. So if you're in a fixed term lease, generally you cannot just serve a 60-day notice to terminate that lease. You must wait until the lease expires. So month to month is much easier or month to month you are able to serve a termination notice as long as everything we talked about lines up. But when you're in a fixed term, you generally have to wait till the term expires.
So Yeah, I understand. Yeah, I wasn't really saying that you could get them out early on the lease, but are there differences in the legal rights of the tenants versus having a fixed term lease versus a month-to-month?
Got it. No, because under a month-to-month lease, the same terms of the fixed term lease carry over just on a month-to-month basis. So just because a lease expires doesn't mean the lease is out the window. As long as the tenant stays and pays rent every month, the terms of that lease are continuously renewed.
All right. So there's a question about what is a tenant buyout. I've included, by the way, a copy of the CAR cash for keys forms. So maybe if you just, I know you explained it, but apparently,
Sure.
Yeah, try one more.
Yeah. The most simple way to explain it, a buyout is when a landlord offers a tenant money or another incentive for the tenant to voluntarily leave without having to serve any type of eviction notice. And so usually it's a set dollar amount in exchange for a move out date. Sometimes it can be a rent waiver. It's a way to get around serving an eviction notice to have a tenant voluntarily leave for money.
Okay. There's a question about what, first of all, Ken would like to ask a question. You're going to hear from one of our members. Go ahead, Ken.
Yeah, hi, Anna. Thanks, by the way, for coming today. On the buyer's side, we see a lot of listings in the MLS where it'll say the property is tenant occupied. And for example, tenant promises to be out by, for example, now it's the end of May, the end of May 25th. How can we protect buyers in that situation? Because we don't see copies of the lease. What happens if the buyer, decides to do U-turn and says, I ain't going nowhere. We've already come to the close of escrow, and now we've got a situation that looks like it's going to go to litigation. How can we protect the buyer in that situation?
Great question. Having a contingency would be helpful, although I know this market is crazy.
You can't write contingencies now. And also the contingencies will be gone. I mean, in fact, at the close of escrow, the seller is in breach of contract. He hasn't delivered the property vacant. But then on the other hand, the tenant is saying, I'm not going anywhere. I'm protected by the eviction moratorium. Buyer is ready to move in. Money has changed hands.
Yeah, it's a risk that the buyer is taking because the seller is claiming they will be able to deliver vacant, but the seller really has no, and depending what city we're in, of course, but in general, the seller does not have a lot of teeth behind that statement, because if the tenant right now in this COVID era says, I'm not going anywhere, a seller is not going to be able to quickly move an eviction through the court to get the tenant out to be able to deliver vacant. So it is a big risk that the buyer is taking. Yes, you may be able to sue the seller for breach of contract or misrepresentation, fraud, all those claims. But buyers do need to know that even though you see that the tenant is promised to leave at the close of escrow, it really lies with the tenant to be able to fulfill that.
There's no, forms or paperwork that we can use or that you would recommend to protect our buyers. I mean, it's just...
Well, it's hard because, the buyer is going to want to have some kind of guarantee or assurance from the seller. And then the seller just may not be able to deliver that assurance because it's going to be up to the tenant to vacate right now because of these COVID-related eviction moratoria. So the short answer is, even if you've got a form like that and the tenant doesn't leave, you're probably going to end up, the buyer and seller are probably going to end up in litigation over it.
Okay, thank you.
And there's a question about more specifics on the seller rent back issues.
Sure.
Other than they won't leave. Go ahead.
Was there a more specific question or just?
Yeah, there is. What are the issues with seller rent back situations? Can you be more specific?
Got it.
That's the question.
Yeah, I'll give a couple of examples on cases I'm working on right now. One is out of Oakland, the escrow closed. Seller had, I think, a 2-month rent back. It was a couple, they got divorced. So the husband left, the wife didn't. So unfortunately, in that situation, we're litigating it because the seller breached the contract, but the wife wasn't an owner. She wasn't the person who entered into the contract. It was the husband, and he performed. So he left a holdover occupant, his ex-wife, in the property. So that's one issue I'm seeing. The other case that I'm working on is escrow hasn't closed yet, and they are negotiating the terms of a seller rent back, and we are trying to keep it to 29 days because anything less than 30 days is not a tenancy. And so what we're doing in that particular situation is we are doing a holdback in escrow. So for every day that the tenant, I shouldn't say tenant, for every day that the seller doesn't leave after the move out date, money will be held back in escrow, $700 a day, something like that, for every day that they refuse to vacate. So I just mentioned the seller rent back issue because I'm seeing more and more of those. They're very, very fact specific. And so if you have questions, you should direct your clients to talk to counsel before you agree to do one.
Is there a difference legally between, I know there's a difference between a license and a lease, but you mentioned 30-day, right? So is it possible, first of all, is it true that you could, assuming it's in not a specific city, but there's a special moratorium, give notice to somebody, evict somebody easier if it's a license than if it's an actual lease?
Yeah, so a license is when one person grants another person a right to stay at a property, but they are not receiving rent or any kind of license fee. Because once the person pays a license fee or rent, they're considered a tenant. So no money or consideration can be exchanged in return for that license, because at least in some cities, once you pay any rent or money for that, they're a tenant, they have rights. So that's the one difference between a license and a tenant, or a license and a lease. And then whether it's easier to evict, it does depend on where you are. For example, San Francisco bans what we call like intermediate length, non-tenant occupancies. You're not supposed to have licensees. But other cities, like you said in your hypothetical, where it's a non-rent controlled, non-eviction controlled jurisdiction, theoretically you could serve a notice to terminate that license, but you can't just change the locks and say, your license is terminated, I'm changing the locks. You still have to go through the court eviction process, even though they're not a tenant, they're a licensee.
Yeah. But 30 days versus 60 days, is there a day limit on a license?
29 days or less. So once the person stays there 30 days, 31 days, 60 days, and they've paid rent, they would be considered a tenant.
All right. A question, my client is moving out of state and there's a month-to-month tenant in his in-law unit. He's given 60-day notice. What if tenant does not leave? Daly City is the location.
Depends when the notice was served, because of the laws we talked about with the Tenant Protection Act, just cause was probably required. So if the owner served a 60-day notice but did not have just cause, it may be an invalid notice. So that's one thing to evaluate. The second thing to evaluate is if the tenant doesn't leave at the conclusion of 60 days, the owner may need to file an unlawful detainer or an eviction lawsuit to have the person leave. They couldn't just change the locks, but that's presumed to be if it's a valid notice, then you could move forward. If it's not, the property owner may not be able to serve that eviction notice.
One final question, I think, is what is the likelihood the moratorium is going to be extended beyond June 2021?
Yeah, good question. I get that a lot. In my opinion, I think the chances are higher. Don't have a crystal ball, but they've continuously been extended. There's a lot of industry chatter that these laws may stay in effect through the rest of the year, 2021. So if I had to gamble or bet, I bet they will get extended, but don't know for sure.
The California Association of Realtors has a rent cap and just cause addendum, which my understanding is that document, or a similar document, is supposed to have already pretty much been given to all tenants. And that if you're going to give somebody notice, don't you have to already have given them notice of the existence of these laws? And is there a form that they need?
Yeah, generally, yes. Besides the CAR form you talked about, the California Apartment Association, CAA. That organization is a statewide organization for property owners, and they have forms available to give tenants, to give them notice of a lot of these rules, aside from CAR forms. So CAA is a good resource, and then a lot of cities have their own. San Francisco, for example, has SFAA, San Francisco Apartment Association. They have their own forms specific to that city. So CAA, good resource for statewide forms.
Okay. So speaking of statewide forms, the PEAD, the Personal Entry Advisory Declaration form. So if the seller has tenants, I don't know if this is part of what you deal with, but doesn't that form have to be given to the tenants, right? So that they can, so that they're given the advice when we're showing the property and those people fill out a P form, the visitor form, is a copy of that given to the tenant? Or, you know, or to just, you know?
Yeah, I would direct that question to, you know, like your risk management or general counsel at your brokerage. We do see PEAD forms come across our desk, but we don't deal a lot with the CAR forms. So better question for the, you know, risk management or general counsel.
Right. I was just wondering if the rules, I assume that since they're the occupant, they're supposed to get a copy of the forms, right? If whether you use a CAR form or some other version of it. I don't know, but I'll ask. Just one, somebody texted, I just want to double check. Seller rent back should be done through license with no consideration. Instead, money should be held back in escrow, so many dollars a day. I think that still qualifies as for consideration, but how do you, is that how you're supposed to execute a seller rent back?
They are so fact specific. So I would say it's hard to give a blanket answer to that question other than to say, watch out for any seller rent back or seller license to occupy the property after close of escrow. Watch out for anything more than 30 days, because then you're tiptoeing into tenant rights lane, you know, tenant rights world. And then these moratoriums that we just talked about can be triggered. I wouldn't say there's only one right way to do it, and it does depend on what city the property is located in. So sorry, I can't give a blanket answer to that, except to say 29 days is better than 30 or more, but there's nothing stopping a seller from saying, oh, day 29, I'm staying to day 30. So each situation really needs to be worked out depending on the facts and how long the seller wants.
Are there any other questions out there? You've been a questioning group so far. Wow, wait a second. This is a really long one, foreclosure. So this is a really long, sort of a specific of an incident. So we're probably not going to go through a case study. It's really long. I don't know if you can see the question. It's a long one about the street address, and they never signed the lease agreement. So unless you want me to read the whole question, you want to tackle it, my suggestion would be if you have a client with a difficult situation, particularly one with lots of particulars, that you get the client to talk to Anna rather than go through it. But I'll read the question if you want to see if it sounds like something you want to.
Yeah, I would say to the person who asked that question, it sounds like it's very fact specific, and I probably would need more facts to answer it. So you're welcome to call or email me. We can set up a consultation. Doesn't have to be me. Tell them to talk to any lawyer that specializes in landlord, tenant, and real estate. But to protect yourself as the agent, have them talk to an attorney.
Right, because in this particular, from what I'm reading, the person's not moving out. It's gone to be, you know, it's not a general question. It's how do you get rid of somebody, I think.
Okay.
Is more of a, it looked like something that would be better done individually. So if you've got specific questions, the reason I'm doing this is because I, you know, coach and mentor a lot of people, and this is coming up. And you know what I've also included copies of the quick guides from CAR and copies of the CAR forms, most of them that are related to this. But my reason for attaching them was not so much so that you would study them to learn and figure out how to fill them out, but rather instead that you would see the number of forms and the complexity of them. And the idea is that if you actually have the situation, you're representing a seller and there's a tenant, the seller ought to seek legal advice about what to do with the tenant, rather than real estate agent advice about what to do. We know what we would like, and it's probably what the seller would like, but that may or may not be legal. The form name for an adjustment of rent, I think there are copies of the forms, but is there a special rent adjustment form as a result of COVID?
Like a rent increase?
Yes, I don't think they're lowering it, but yeah, that would probably be.
Oh, if they're lowering the rent, there's definitely a whole host of things. Like if they're giving a credit because tenants are having hardships, that's a whole separate topic. There are forms for that. If they're doing a rent increase, certain cities require certain language in the forms. There was a change of law last year, so if the rent increase is more than 10%, it's 90-day notice now, not 60-day. The CAA, California Apartment Association, does have forms. A lot of things to be aware of with respect to rent increases. I talked about Penal Code Section 396 that prohibits rent increases over 10% during a declared state of emergency. So a lot of things to be said about rent increases and temporary decreases as well.
All right. Well, that may be enough for today.
All right, that was a lot.
That was an excellent job. I really appreciate it. You answered a lot of questions. We've kept most of them for the whole time. So again, if you guys have any questions, reach out to Anna. They specialize in this kind of law in this area. And so you ought to recommend that your clients get legal advice. So that's all we've got tonight. Today. Thanks a lot for joining us, Anna. Everybody stay safe out there, and I'll see you guys next week.
Thank you, Michael. Bye.